Welcome to the Schiller Hamilton Podcast, Derek. Welcome back.
Thanks, man. It's been a while.
It has been a while. I mean, I kind of feel like it's been several weeks at least since we had the chance to sit down in here.
I think it's been a couple months.
Well, summer's busy.
It is.
People are traveling.
Yes.
We've had vacations. Everyone's been in and out of the office.
Yeah.
So I think we can forgive and excuse ourselves for at least missing a few days here. But I'm glad we had a chance to sit down today because I wanted to talk about something that we both get asked about constantly. And that would be what happens if I was already hurt or injured before this new accident or injury. We call them preexisting injuries and conditions.
That's right.
You ready to talk about this?
Let's do it.
Let's do it. Okay, let's get right into it. What is a preexisting injury or condition?
Well, the easy answer is exactly what it sounds like it is. It's going to be some sort of injury that existed prior to the new injury that someone is claiming a personal injury from, or it's some sort of medical condition that existed that they had, whether that be a disease or some sort of condition that was going on prior to a new injury that was caused due to someone's negligence or intentional act. That's what we talk about it in the context of a personal injury case.
In non-lawyer speak, it means you were hurt before.
Yeah, whether it be years before, days before, or it's some underlying condition that you either do know about or don't even know you have,
right?
Which may affect how your personal injury case goes.
And I think maybe the classic example is some degenerative spinal condition.
That is one of the classics.
Classic example. A lot of degenerative changes in disc because you basically can't have any imaging with someone over, say, 25, 30 years old without that imaging showing some degenerative change in someone's spine.
That's exactly right.
It just happens every time, whether that person's symptomatic or has pain or not, right?
Yeah. I mean, it's a natural, degradation of your body. I mean, it's just like anything, your body's going to age. And different people suffer from it at different variables, but it is definitely probably the most common. But, to open it up a little bit more, it really raises its head in two different things. Either there's a prior injury that is worsened by a new injury, or there is a medical condition, whether that's known or not, that makes somebody more particularly susceptible, either to injury or some, unforeseeable or uncommon reaction to an injury.
The eggshell plaintiff.
And we'll get to that, which is a very interesting legal doctrine.
Well, why is this a problem? How in what way do insurance companies or defense attorneys use pre-existing injuries or conditions to the detriment of a plaintiff bringing a case?
Well, it's really just one of the tools in their quiver, so to speak, to attack a claimant or a plaintiff's case. Insurance adjusters and defense attorneys use it to either shift the blame from the injury caused by their defendant or their, at-fault party, and say that, this was just symptoms of something that's existed before and nothing new happened to change it. This is just something you're dealing with and you're going to continue to deal with, and it's not our fault. Or they do it just to try to reduce and attack anything they can to reduce your damages, reduce what you had going on with your life, reduce the pain you went through, and then ultimately reduce the compensation that you deserve to receive. So it's really just one of the few things that they try to use, just like anything else, that attacks, good working people, good people who are injured at the hands of someone else. And then another thing that I'll say that you try to use when it comes to the pre-existing condition, like a medical condition, is they'll try to say that regardless if someone had some condition, either they knew about it or not, and it results in some very uncommon result from a minor injury, then they'll try to, use it as an excuse to say, well, an average normal person wouldn't have had that reaction. They wouldn't have had that, that kind of pain or that kind of injury from a, say like a low-speed collision or something like that. They're going to try to just pigeonhole everybody into the average person, not really caring about what that person may have, like we talked about, like a degenerative disc disease, or maybe they already have arthritis or something like that.
Right. So they basically it's a very speculative argument. Well, someone should not have been hurt in that wreck, so therefore your person was not.
Yes.
Just like most people walking around are not struck by lightning, but that doesn't mean no one is ever struck by lightning.
Exactly right. That's exactly right.
Bad things happen at the extremes of probability curves, right?
That's exactly right.
So, but that doesn't mean hope is lost. And I think, again, what we tend to see, sort of the classic example, is perhaps there was a pre-existing injury or condition, but then that pre-existing injury or condition is worsened or aggravated by whatever, the car wreck or the fall or whatever happened. Tell me a little bit about that. What do we do? What is the plaintiff entitled to when a condition is worsened or aggravated?
Well, the good thing is the at-fault party and their insurance carrier, they're on the hook basically for anything that is worsened. Just like any case, we're going to have to prove that it was proximately caused by the negligence or the intentional act of the defendant. But the good thing is the courts in our common law have established the fact that they are actually liable for these injuries, okay, and the worsening of a prior injury, okay? They don't get off scot-free just because you previously had an issue with your knee or your back or something like that. It really comes down to the distinction between how permanent this change is, okay? And that comes down to two different words that are going to sound exactly the same, but aggravation and exacerbation. Those have they sound like they're the same word, and they pretty much have the same meaning in typical, language. However, it kind of comes out of workers' comp law that they have distinctions, okay? And that's applied also into our case, and it's just a good way to use words that mean what we mean for them in a personal injury case. So let's talk about aggravation first. And aggravation is going to be a more permanent change, okay? So there's an injury that exists, and this new injury that's at the fault of the tortfeasor is going to cause a general elevation or raising of the severity of that illness or that injury, okay? So the degenerative disc disease, it is a tongue twister, is the classic example here. So say we have a client who has degenerative disc disease. They go to the chiropractor on a regular basis, but not like every day, maybe once a month or something. They're going to a chiropractor and they're treating this. It's something they live with. They're in a minor vehicle collision, okay? It's not very strong, but because that person had this prior injury, say now one of the discs in their back is ruptured or herniated. Well, they still have the degenerative disc disease, but it's now elevated to a much higher level. They're going to have more treatment. They're going to live with a lot more pain. If a disc is herniated, it's not like it's necessarily going to call for surgical intervention, but they're going to have more therapy, and they're going to live with more pain, and they maybe have injections, things like that. So their general level of their disease is now elevated. So that's an aggravation. An exacerbation is going to be more temporary in nature, okay? So it's going to be a temporary worsening of the symptoms of a prior injury, okay? A good example of that would be, say we had a client who played football in high school, and then say he suffers a fall, like a slip and fall injury, and either twists his leg, twists his knee, or hits his knee. Something causes, say, like a flare-up in arthritis, or, it causes swelling. And so even if he had arthritis before from a prior injury, he now has a temporary elevation of that injury. He's going to have to treat it, but after treatment and proper, everything he does, he's probably going to be back to normal.
Mm-hmm. His normal,
right. Exactly right.
And that's really what it comes down to.
Yeah.
Is the before and after, right? So
exactly,
whatever your normal is, whatever degree of change there was after whatever tragedy that befell that person, that's what the defendant is really on the hook for.
That's right.
But I mean, I think the law is kind of the easy part because it's really just degree of change before and after. But in practical terms, oftentimes there's a proof problem.
Yeah.
And it really comes down to, what can you actually prove and how do you prove that before and after? Talk a little bit about how we go about proving the degree of change in the before and after.
Well, you kind of mentioned your normal. So the first thing we need to do is we need to establish what was your normal. What is the baseline of either your treatment of the injury you had before or what symptoms you had or anything like that. So, and that needs to be before the new injury. So if you're treating the injury, we can obviously get that from medical records. If you're something like my hypothetical, someone's going to the chiropractor, we can see what they're doing and the type of pain they're living with and things like that. You're also going to have to prove, just like any negligence case, that the new injury or the worsening in this case was proximately caused by the actions of the defendant. So that kind of can be really tricky sometimes when there's multiple injuries and it's trying to nail down that actually this worsening also happened in addition to, say, other injuries that may be completely new. So that's obviously a critical point. And then also we have to determine, and it's very critical for damages, how permanent is the change? If we're talking about an exacerbation, then we're only talking about past pain and suffering or current pain and suffering and treatment and medical treatment. If we're talking about an aggravation, that may be a lifetime disability. It may just be lifetime pain and suffering. Those are definitely some distinctions that someone needs to make, and you don't need to rush into settling or trying to move forward with a case like that until you know how permanent is the worsening going to be. So those are kind of the three things that are not really in your normal run-of-the-mill personal injury case that have to be looked at, and those check boxes have to be checked, and you have to really establish those facts and make sure you have all that ready.
And I think to complicate matters even further, sometimes even looking at prior records versus new records, there could be a lack of clarity or a lack of distinction between two problems that are separate but might appear to be related just in a cursory reading of the records. For instance, if you have a client who has a head injury, and this has happened to me, and I know you several times, where they had previously treated for headaches that were actually caused from sinus issues, but they go to the doctor complaining of headaches, they're sinus headaches.
Yeah.
Now they have a head injury, they have a completely different kind of headache that they can describe to you how it's very different, and now it's more related to the post-concussion syndrome or the effects of the brain injury. But on paper, you have a document from before the wreck that says complained of headaches, and after the wreck, complained of headaches. So your before and after, if you look at the records, kind of looks the same. What's the role of client or patient testimony in determining distinctions between before and after in a case like that?
I mean, it's definitely critical in certain cases. I mean, if we don't have a record of treatment to establish that baseline, well, the baseline is going to come from their testimony. And if we do, they're going to be the only person who can really make those distinctions. Because like you said, the record may be very, basic. It may be completely broad like that. Headaches are headaches. Well, they're not.
Yeah.
I mean, even within headaches, anybody who knows they have a headache, they know there's stress headaches, there's tension headaches, there's headaches that come from neck injuries, there's migraines. I mean, there's all different types of headaches. I've actually had this happen. And then also I would say outside of the client's testimony of themselves, an expert may be needed. I've actually had the reverse of that where we had seemingly, different injuries, but it affected something. So I had a lady who had arthritis in her knees. She had issues with her knees, had knee surgeries years prior. And she suffered through arthritis. Okay. She's about in her 50s. She suffered a fall and had a torn meniscus. So completely separate injuries, but, she treated the new injury, completely new injury of the meniscus tear. She also had an exacerbation where it was a swelling and a flare-up of her arthritis that was super painful for a month or two. That kind of went back down. She had some injections and things. But the critical point on this is we had a medical expert that came in and testified that not only was it exacerbated, but it was also aggravated. The term he used was accelerated. He basically testified that her arthritis in her knee was now accelerated from that of a 50-something-year-old to a 70-something-year-old.
Right.
So that was going to be a permanent issue she lived with.
Right. And that may accelerate the need for a knee replacement.
Exactly.
Yeah.
So you never really know how it's going to raise its head, and it can really come in all different forms, different parts of the case, and you really, like I said, you have to be extremely detailed, and we have to make sure we're getting everything we can from medical records from the client and utilizing experts if necessary in order to prove, like we said, what's the permanency of this? Because a lifetime disability like that is a big thing.
Yeah, and the one other resource that we pull on oftentimes, in addition to the client themselves, as well as the medical professionals, is also don't forget the people around them.
Oh, yes.
Who actually observe them on a daily basis and can provide testimony about their physical abilities and habits, what they tended to do for fun or what they're unable to do now. And this is especially important in brain injury cases where it can be very difficult to diagnose. And sometimes the person who's suffering the injury isn't even really aware fully of the before and after. They might not be aware of their mood swings or sullenness or, how they've become more withdrawn. But those are all somewhat classic symptoms of someone having suffered a severe concussion and the lingering effects of that. And oftentimes it's spouses or children or, anyone that you cohabitate with, friends, who might be able to provide that testimony about what they see. And that can become really important in corroborating diagnoses or
certainly
corroborating what the plaintiff is saying as well.
Well, certainly, a lot of times clients can't really articulate maybe how things, because they're with them, obviously you're with yourself every day. Mm-hmm. And minor changes like that aren't as, it's like the example of like your child. You see your child every day, but then when you see your family members or something, they're like, oh my gosh, they're growing so much. And it's kind of the same thing. If you have people who you see in your daily life, but it's not every single moment of the day too, they maybe can testify to changes because there's more of a gap too. So like you said, there's all different things like that need to be explored and utilize every single, source of the facts that you can. So,
you mentioned earlier the problem when someone may be more inclined to suffer a particular kind of injury.
Yes.
I haven't. Yeah. So can we talk about eggshell plaintiffs now?
Yeah, I think we've covered pretty much pre-existing injuries.
I want to talk about. Yeah, tell me about the actual. Here's the thing: no one seems to really understand what that means, and it means the opposite of what the layperson or what most people think it tends to mean. Really, frankly, it means the opposite of what most insurance adjusters think it means or the way they use it. Tell me about the case. Tell me why we have the term eggshell plaintiff and what it means.
So, like we said earlier, the other kind of form that this can take it in a personal injury case is going to be when, like you said, someone's more particularly susceptible. One of the legal doctrines that's based upon is called the eggshell plaintiff or the eggshell skull rule. It dates back several hundred years back to English common law. I think we probably read a case in law school from English common law in the 18th century or 16th century from like.
Maybe Wisconsin.
No, yeah, that's here. Yeah. But I'm saying it has
the original case.
Oh yeah, it has a basis all the way back in English common law, and I believe that case involves someone who did have a thin
actual eggshell skull, right?
Now, it has a long-standing tradition here too, over 100 years, probably 150 years. One of the early cases, like you said, is from Wisconsin, Vosburg v. Putnam. It's from 1891, and we actually have a pretty cool little video that shows a little bit about it.
Look at you.
Yes.
Look at Trent being ready for that video.
Andrew Vosburg and George Putney sat in the village high school in Wisconsin. George reached across the aisle with his foot and tapped Andrew's right shin with his toe. Andrew showed no initial response, but shortly thereafter felt a violent pain in his shin, causing him to cry out loudly. Earlier in the year, while sledding on January 1st, Andrew received an injury just above the knee on his right leg, which appeared to be healing at the time of the classroom incident. One of the medical witnesses theorized that because of the sledding accident, the limb was in a diseased condition when George's touch occurred. Andrew will never recover the use of his limb.
So I really like that video because one of the things that doesn't come across when you're reading this case is how lightly the one boy touched the other boy. But to kind of follow up on that, what happened is they had the trial. The jury basically gave them standard, damages for what had happened, like just the injury that had happened. It was a very light kick. It shouldn't have caused this completely unforeseen issue. And, eventually it went to the Wisconsin Supreme Court, and they held, that no matter how unforeseeable, no matter how uncommon, the defendant was responsible for all of the injuries to the plaintiff. So that is an early case that just truly exemplifies because, like in the video, it's such a light touch that no one could ever reasonably believe that it would lead to the loss of the use of his leg.
Yeah.
And even that disease was unknown to him. I think, there's some theories as to maybe there's some microbes and some bacteria that had gotten into the wound from when he hit the rock. and it eventually had gotten into his bone, and due to the fact that there's not much meat in between the shin bone and your skin, when he was tapped and kicked by the other kid, that basically pushed that bacterial infection into his bone, and his bone, never recovered.
Wow.
So it's just one of those really wild cases that really did establish that this is alive and well in our common law. And, the neat thing about it is that it just, from a very early time, established that no matter what it is, how uncommon it is, you're going to be on the hook for it as long as it is, proximately caused by your actions. In practical application, what it means is you take the plaintiff as they come, okay, or the injured party, okay, meaning that regardless what they may have, what they have, what they may know they have, what they don't know they have, whether it be injuries or medical condition, when they come to basically the table, so to speak, of this new injury, you have to take them as they are. And that kind of sets up exactly what we said. It doesn't matter what the problem is, how susceptible it makes you, how unforeseeable or completely seemingly random the injury may come out of it, that if it's proven that it was caused by the new injury that was caused by the defendant or the at-fault party, they're going to be on the hook for those damages.
Yeah.
So, it's been used for, hundreds of years, and, fortunately it's still around here, and it's still here today. And, it's something that we can use as part of our toolkit. But you're right, like, it's not what insurance companies think, and they kind of assume that it's more of that traditional thought from England, like
they think that means they don't owe them for the damages. It's an eggshell plaintiff. Well, exactly.
Yeah, they think, your plaintiff. They think, your plaintiff is just particularly susceptible, so that's why it's like a get out of jail free card for them. They think that excuses the fact that our client was injured more than is maybe reasonable, but in fact it means the opposite. So that's just a really neat case, and it's one we learn in law school, and
that was cool with the visual. I've never seen that.
I like the visual because, again, when you read it and it says that he was kicked, well, how hard was he kicked? And that came from a website that had a brief about the case, and it really established the fact that this was a very light kick. I mean, if you read the text about it, they were sitting in class. It's not like they were on a playground. I mean, it was just like if I tapped you under the table here today. So that's kind of eggshell plaintiff, and it's definitely something that we still use today, 130 years later.
So with just the vast number of potential complications, why is it important for somebody to seek representation if they've had any pre-existing or prior injuries or conditions?
Well, like we talked about, is that this is just something that we know that insurance adjusters and defense attorneys are going to use against a plaintiff or an injured party. And so it's critical that you have representation. And I would say you actually need representation from an attorney who has experience with these pre-existing conditions.
Yeah.
Because it can throw off attorneys.
The law is the easy part. Again, it's proving everything that's really difficult.
Exactly.
That's where experience really comes to play, right?
It does. And I would even say, I'm not speaking of anyone in particular, but I'm just saying some attorneys who maybe do personal injury on the side. I mean, this is not something that comes up as common as you would think. The degenerative disc disease example kind of does come up a fair amount, but generally it's exacerbations. Exacerbations, most people probably could escape and be okay with, I didn't look at that closely. But if you have anything that's an aggravation, it's going to be more permanent in nature, or it's an eggshell plaintiff type case where, we have a small bump up. We've had one here with a gentleman with a series of back surgeries, and he was involved in a very large vehicle. He was in a bus. And so, of course, their argument was mechanism of injury. It's a huge bus. How could he be hurt? Well, they didn't take in the fact that he is more susceptible to that type of injury. So I would say, someone who has that experience is critical. Like you said, is proving everything, knowing what to look for, what to go after, how to establish it. Like we said, from the client, from the medical record, from friends and family, getting everything, and having the resources to also seek an expert if necessary.
Yeah, because oftentimes in those cases, that's what it comes down to is medical testimony and expert.
Yeah.
and having the ability and understanding to properly depose a doctor, to lead them or to get them to explain the differences of the before and after, and have a level of understanding of the medicine to be able to ask the questions that are necessary to get that doctor there.
Exactly.
And also the resources to bring in outsiders, perhaps another doctor, a non-treating physician or other expert in the field who can give an opinion as to, you know, what one could expect long-term from a potential degenerative issue versus aggravation or acceleration. All those things are very important, especially when you're talking about something that will affect someone for the rest of their life.
Yeah.
And if there's any degree of change that may or may not be permanent, it's a good idea to start preparing for the worst and hope for the best.
Always have to keep our eye out for the future.
Derek, thank you. I appreciate
problem.
you coming back in and sitting down with us. Let's not go another month of summer
sure.
before we do this again. So,
Exactly.
all right, man. Look forward to it next time.
Thanks, Joe.